The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Hello and welcome to Short Circuit, your podcast on the Federal Courts of Appeal. I'm your host, John Ross, joined this week by regular panelist Evan Bernick, as well as special guest Justin Pearson, an IJ litigator and managing attorney at our Miami office. This week on the show, privacy in your pants pockets, a biblical monument on the public lawn, ballot selfies, and an unfortunate series of events that lead to a SWAT raid. Justin, kick us off.
Well, the first case comes out of the D.C. Circuit, and it involves actually not one but two SWAT raids, really for no good reason. This involves a military veteran who is suffering from post-traumatic stress disorder, which has already been diagnosed, and he's on medication. And he calls a veteran's hotline, or attempts to, when he accidentally dials a suicide hotline. He explains that he's not suicidal, but to make a long story short, the hotline operator calls the police, and they show up at his apartment. Eventually, he responds to their knocking on the door and phone calls, and when they take him out, they do an initial sweep, which was not the reason for the lawsuit primarily. After 5 hours of investigating the reasons why they were there, realizing that those reasons were not accurate, asking him for consent for them to do a more thorough investigation of his apartment, having him object, they decide to go ahead and search the apartment anyway, even though they've made no effort to get a warrant. And not only do they search the apartment, but they search it on a very detailed, destructive level. They damage many of his items. They ransack the whole place. They turn it upside down. When he eventually comes home, his whole place is a mess, and he's upset. And so he files a lawsuit against the officers personally for these egregious violations of the Fourth Amendment. It's a really interesting case because, you have this dynamic where there was already an initial sweep, and so the police, honestly, they should have known better. And so the D.C. Circuit unanimously agrees, or at least the three panelists do, that there is a Fourth Amendment violation here. And where they disagree is whether qualified immunity applies. Thankfully, the majority, rightfully, I would say, determines that the police knew that what they were doing was in violation of the Fourth Amendment, and that the case should move forward.
Evan, let's get back to the raid real quick. Once they pull him out of the house, he doesn't go back for quite some time. Why is that?
He doesn't go back for quite some time because he's actually being taken to the police station, and he is in custody with the police. You have a 5-hour time period during which the police have after which the police have talked to his neighbors, shut off a gas leak, apparently, that was coming out of his building, swept his apartments, found nothing that would give rise to any suspicion of criminal activity or that he's a threat to himself and others. And then, unaccountably, infuriatingly and bewilderingly, they return, they enter his home without a warrant, despite the fact that they have, again, no reason to believe that there is any criminal activity going on, and despite the fact that within 5 hours, they could have easily been sought and probably have been denied a warrant to enter. The officer's conduct throughout this whole situation is really abominable. And the only question at the end of the day is whether the judicially created doctrine of qualified immunity, which insulates officers from civil suits resulting from constitutional injuries they inflict, is going to get them off the hook. Thankfully, the majority came to the conclusion that in the context of the second raid, given the egregious character of the police officer's behavior, qualified immunity did not apply.
It's egregious for some other things that we didn't mention, namely, allegedly, the officers left the stove on in his apartment, and he was ultimately gone for 2 weeks. So the stove's on for 2 weeks, we think, possibly.
Right, to the extent that there was any danger in the apartment, it was created by the officers as a consequence of leaving his stove on.
And there's some other egregious behavior that we haven't mentioned yet, namely that allegedly the officers left the stove on for up to 2 weeks. Also, they left his front door unlocked while he was gone. So they created more danger than he did possibly. Moreover, when he objected to the raid, the officer's response was what?
Don't give me that constitutional bullshit. we're going in and you're paying for it. So this is a guy who's presented himself peacefully. He's lying there on the ground. He has said politely but firmly, I do not give you consent to enter. And he's bullied by the officers for asserting his constitutional rights.
And the dissent takes what view on that, Justin?
Well, I think that's one of the most interesting things about this case is that one of the three judges actually dissented on the issue of qualified immunity. They unanimously agreed that the Fourth Amendment had been violated. But despite this ridiculous fact pattern, there was still one judge who said that even this did not rise to the level where the police could be personally liable, that qualified immunity is so all-encompassing and so exacting that even this fact pattern did not qualify. Thankfully, that was not the majority view, but I do think it is an example of just how much deference these judges are tempted to show to the police, even in ridiculous situations.
Right, and the dissenting judge draws upon a very deferential line of Supreme Court cases, in particular recent cases, that seem to stand for the proposition that qualified immunity is actually absolute, unless the police officer has acted wildly incompetently or egregiously. The thing is, the officers in this case did act incompetently and egregiously. This is that extreme case. So even if you take a very deferential view of the Supreme Court's qualified immunity jurisprudence, the fact of the matter is that if this doesn't qualify, qualified immunity is not actually qualified at all. It is absolute. I think the majority definitely came to the correct decision, and I'm really mystified by the dissent.
Okay, let's move on to the next case. Evan?
So this case involves the perennially ripe issue in constitutional law of the constitutional status of large displays, or really any displays, of the Ten Commandments on public property. This case comes out of Bloomfield, New Mexico, and it involves a very large statue of the Ten Commandments. It's about 5 feet tall and weighs about 3,000 pounds that was planted outside of Bloomfield's municipal complex. So if you want to pay your water bills, you've got to go past it. The monument was approved in 2007, but it was only actually installed in 2011. And the question is whether having this privately funded but prominently displayed on public property monument that says, among other things, I am the Lord thy God, you shall have no other gods before me, is an unconstitutional establishment of religion because it communicates to non-believers or believers in many gods, among which are the plaintiffs, they're Wiccans, that the government is endorsing religion.
Justin, what does the 10th Circuit arrive at?
Well, the 10th Circuit, in what I would say is a very judicially engaged opinion, reaches the correct result, and they determine that this actually does violate the Establishment Clause. And this is despite the fact that the proponents of the monument and the government had taken subsequent measures to try to cure the problem. And it's clear that this was done just to try to avoid the type of analysis that is shown in this opinion. And the court doesn't buy it. The court, engages with the facts, realizes what was really going on, and comes to the conclusion that this was done for religious purposes.
What sort of steps did they take to cure?
Well, they took a couple different steps. One, they inserted disclaimers. These included a small disclaimer on the Ten Commandments monument itself, as well as a slightly larger disclaimer in the ground next to it. They also added other secular monuments, such as the Bill of Rights and the Declaration of Independence. But this was all done after the fact. And so despite these steps, it was clear that the actual purpose of this was to promote this religious belief of the person who paid for the monument, as well as certain people within government.
Right. So what the court does is a very context-sensitive analysis. It looks at the perspective of a hypothetically informed observer who knows everything about the relevant context. They know how it was proposed. They know the terms in which it was proposed. They know that when it was initially dedicated, there were prayers, unlike in the context of the presentation of the other monuments. They know that it was raised by soliciting churches, and they know that the the relevant text itself, the disclaimers that were eventually put on it, were hardly unambiguous concerning whether this was an endorsement of the sentiments that were expressed by this monument or the other monuments. It says these views, these monuments don't necessarily reflect the views of the city, but they might. It's far from an unambiguous disavowal of the views that are expressed. And the court, looking at this context, comes to the conclusion that yes, a reasonably well-informed observer would have come to the conclusion that this was an endorsement of religion.
This brings to mind a Judge Easterbrook quote for you, Evan, doesn't it? Yes,
Judge Easterbrook has, of the Seventh Circuit, has said something about the Court's Establishment Clause jurisprudence more generally that has always stuck with me, and that it resembles an enterprise more akin to interior decorating than to adjudicating. Notwithstanding that, it's important to stress that judicial engagement is not a theory of constitutional interpretation. It doesn't say that the Establishment Clause should be understood in a particular way, that's the meaning of the text. It says, to the extent that the Constitution is implicated, to the extent in this context that the Supreme Court has said the government may not endorse religion, you need to engage in a context-sensitive analysis that takes into account everything leading up to the measure that's being challenged, how it would have been understood, all of the relevant facts before you come to a conclusion. And that's what the court did in this case.
Well, that's the definition of judicial engagement. But what do you mean when you say interior decorating?
So in the context of Establishment Clause jurisprudence, judges are constantly scrutinizing the arrangements of various displays, whether it's a creche inside of a courtroom or it's a statue of the Ten Commandments in a public park. Judges are looking to whether an observer would understand that this is an endorsement of religion by focusing on such things as, okay, where is it placed? How many people can see it? When was it placed? Is it surrounded by other secular things, or is it just kind of standing by itself? So it's very nitty-gritty stuff that focuses on aesthetics. And to that extent, it kind of looks like a decorative enterprise rather than an adjudicative enterprise. But if one takes seriously the proposition that the Constitution forbids states from endorsing religion, that's the kind of stuff you have to do.
And it's interesting that, for the rights that the courts still care about, like the Establishment Clause, they're able to do it. It's unfortunate that they don't choose to do it for all constitutional rights.
Yeah, I mean, this case really puts to lie the notion that judges are somehow incapable of inferring purpose from the fact that the government has taken a particular action, or, it's just such a hazy fog and who knows what people were intending. Sometimes we get that in economic liberty cases. Well, a bunch of legislators might have been acting for protectionist and therefore illegitimate purposes, but others might have genuinely thought that this is a public health or safety measure. In this context, courts look at the primary motivation, they look at the context, they can make judgments about purpose or the ends that the government is seeking. So it's completely fallacious to reject the notion that judges are incapable of doing that kind of analysis in economic liberty cases, but they are capable of doing that in Establishment Clause cases.
Justin, talk to us now about the latest ballot selfie case, which comes out of the Sixth Circuit.
So this is a case that's about more than just ballot selfies. It's actually challenging a law that goes back over 100 years, which prohibits voters from showing their ballot to other people. And basically, it comes after some other cases that actually do deal with ballot selfie laws, including a recent case out of the First Circuit. And so what happened here is the plaintiff filed a challenge and sought preliminary injunctive relief 32 days before the election. And so much of the opinion discusses the timing of the challenge as opposed to the merits of the challenge itself. Basically, what happens is the majority opinion is just unwilling to engage with the actual legal challenge. And even though the district court had gone through the relevant standards and had granted preliminary injunctive relief and had denied a motion for stay and basically laid out the correct way to approach this, which is that this is a violation of your First Amendment rights. You should not have to choose between the First Amendment and your right to vote. You have the right to do both.
Just to be clear, so if you do take a ballot selfie in Michigan, the way the election officials interpret the law, your vote will not count.
That's right. If they catch you showing your vote to other people, whether it's through a ballot selfie or otherwise, you lose your right to vote. Your vote will not count. And so this is an extremely serious repercussion in our system of government, which is why other courts have ruled that somewhat similar laws were unconstitutional. But that wasn't good enough for the majority in this case. And the majority opinion basically just goes on a lengthy diatribe about the importance of not waiting to the last minute to file actions. And I get that. Anyone who's practiced before judges at any level realizes that there's nothing judges hate more than having an emergency thrust upon them that was not actually an emergency, that was just caused by delay of the person seeking relief. But that doesn't change the fact that the court should have still gone through the proper analysis. And under that proper analysis, which is shown by the dissent as well as from the trial court, this law is unconstitutional. The other cases were correctly decided. The district court's opinion was correct, and it should have been upheld.
Why is the law unconstitutional, Evan?
The law is unconstitutional, for a couple of reasons. The law is unconstitutional, first and foremost, because it is a content-based restriction on speech that is not justified by a compelling interest that's supported by any kind of evidence at all. And the second reason, related reason, is to the extent that it's not a content-based restriction on speech and it's a content-neutral regulation of speech, you still don't have a substantial interest or a substantially important interest that's supported by the kind of evidence you need to pass muster under intermediate scrutiny. So whatever way you want to slice it, you don't have the evidence to support the proposition that voter corruption or voter intimidation is a significant problem in this context. And even if you were trying to deal with that problem, even if it was a problem, it couldn't be justified by something that was as broad as a categorical ban on displaying your vote to anybody, as opposed to something specific that focused on voter intimidation and corruption.
And yet the majority thought that changing election rules at the last moment would be really difficult, would be really burdensome. Is that accurate? Does the dissent have anything to say about that?
The dissent accurately points out that the relief sought here is not to have the ballots reprinted or for the government to do anything cumbersome, just for the government to tell its poll workers that you don't invalidate votes anymore when someone is taking a ballot selfie or showing their ballot to someone else. So this would not have created any large burden on the government. And the dissent points this out, but nonetheless, the majority just can't get past it. And it's clearly frustrated and angered by the fact that relief was sought only a mere month beforehand. And so the majority opinion really only pays lip service to the relevant standard. The concurrence is a little bit more level-headed and gives it a little bit more consideration, but then gets the standard wrong. I mean, the concurrence actually raises a decent point that, it would be useful to find out how much delay is caused by people taking selfies. But again, the standard is not a guaranteed win or that there are no unanswered questions.
It's a likelihood of success on the merits.
Exactly. And it's clear that there's a substantial likelihood of success on the merits here. And so for that reason, the concurrence is totally wrong.
Yeah, and if you read the majority opinion, the amount of time that's spent focusing on just how much this is going to inconvenience all of these poor government officials and, in particular, all of these poor judges who have to deal with this challenge at what they regard as an inconvenient time, versus the amount of analysis that's actually spent upon the merits, the disparity is really jarring. I mean, you'd have paragraph after paragraph that, beats up on this guy for not bringing his challenge at a convenient time, and then you have a very cursory application of something that really doesn't resemble intermediate scrutiny as defined by the Supreme Court in any meaningful way. You have the majority saying, well, look, it's too much to ask the government to produce evidence that this is still a problem because the law has been, voter intimidation and corruption is a problem because if the law is doing what it's supposed to do, then for the last 100 years, we've been preventing corruption and voter intimidation. Well, if that's true, then intermediate scrutiny really isn't anything. All the government needs to do is say, we've had this law in place for a really long time, and it's working. And we know that because none of the incidents that this was allegedly designed to deal with have happened since. It's very unconvincing analysis. And I would just refer people to the dissent.
So the election's over. He didn't get his preliminary injunction. We don't know if he did take a selfie or not. But what happens to this case?
Well, the silver lining is that he may still win on the merits. And even the majority opinion, as flawed as it is, makes it clear that they're not ruling on the actual merits of the case. Based on the precedent from other circuits, at least one circuit and then one other district court, he should win on the merits. And so hopefully the court will eventually do the right thing. However, even when they eventually do the right thing, that won't undo the harm that they chose to impose during this past election. They could have done the right thing. They chose not to. And so as a result, for this past election, people were forced to choose between two different constitutional rights. That should not have been allowed to have happened.
Okay, let's move on to the last case. Evan.
So this case comes out of the Eighth Circuit, and it's another Fourth Amendment case. It involves one Miguel Craddock, who was convicted of being a felon in possession of a firearm. What happened, and this is a suppression motion. He wants to suppress evidence that was collected during what he believes was a search in violation of his Fourth Amendment rights. Here's what happens. You have a police officer who's patrolling the neighborhood, comes to a traffic light, stops at the traffic light, sees another car enter the intersection, and then, apparently upon seeing the officer, head in the other direction. Officer becomes suspicious. Why is this guy avoiding me? He calls it in. He calls the vehicle number of the car that he's seen moving in, finds out that the car is stolen. He loses track of the car for a while, eventually comes across an individual, that is Craddock, who's walking, and he finds the car relatively nearby Craddock. He stops Craddock and does what's called a Terry stop. Without a warrant, he pats this individual down, searches for weapons, feels something in his pocket, then goes into his pocket and finds keys to a Pontiac. What do you know? It is the Pontiac that has been stolen. The officer's intuition was correct, and when they go to the car and they open it, they find a weapon. So now he's been criminally charged and he's been convicted of being a felon in possession, and he wants to exclude the evidence from the trial.
And what does this hinge on, Justin?
Well, it hinges on the fact that the officer could tell that the suspect had car keys in his pocket or a fob to open up a car, but the officer had no idea whether that was for the stolen car or some other car or some car owned by the suspect. And the court rightfully determines that because the officer could not figure out and had no way of knowing until he took the keys out and violated the Fourth Amendment, the officer had no way of knowing, which car went with those keys.
Well, a Terry frisk is obviously constitutional, Evan. So what's the problem with a Terry frisk that results in a key fob being found?
Well, so the Supreme Court has said that the Terry frisk is constitutional, but the Terry frisk has always been a limited exception to an otherwise ironclad rule that you need a warrant before you can search an individual, and it is limited to a particular context. If you have reason to believe that somebody is armed and dangerous, you can do a pat-down. If, as the Supreme Court has subsequently fleshed out, you come across something that is inherently incriminating, something that is, like a knife or a weapon or an object that you can feel and it's contraband or it's illegal or it's dangerous, you can take that object out and you don't have to exclude that later. In this case, though, you're dealing with car keys. Car keys are not inherently incriminating or dangerous. The fact of the matter is that these keys did belong to, whoever owned the car that was stolen, but that's neither here nor there. Terry frisks do not allow officers to engage in crime investigation on a general scale, even if their intuitions turn out to be correct. And in this case, the officer exceeded the scope that the Supreme Court has defined in the context of carving out a space for warrantless searches.
And so I would argue that this is another good example of a judicially engaged court doing the right thing.
Yep.
And we should give credit where it's due.
Absolutely.
Okay, that concludes the show. Thanks for listening. We appreciate you. Until next time, this is John Ross from the Institute for Justice, directing you to get engaged.